Welcome back to the Two-Way Report. This is your host, Mike. So, there's this new case that the Supreme Court is considering, which involves determining the constitutionality of the federal law that prohibits felons from possessing ammunition. In this video, we'll talk about Joshua Seekins v. United States. Mr. Seekins filed a petition for a writ of certiorari, and the petition was granted last February 21st. His case is currently under consideration for review by the Supreme Court. The significance of this case goes beyond its impact on the federal law banning felons from possessing ammunition and, potentially, firearms. It could also have implications for other federal laws based on the Commerce Clause. Despite the absurdity of the case's facts, it raises interesting questions about the use of the Commerce Clause, which I'll touch on later. The focus of this case is on whether the federal prohibition on felons possessing ammunition is constitutional and whether it violates the Commerce Clause. The plaintiff, Joshua Seekins, is arguing that Congress lacks the power to make the possession of ammunition a criminal offense solely based on the fact that it has crossed state lines and is now in the possession of a prohibited person. On June 17, 2019, Mr. Seekins was taken into custody under suspicion of stealing a U-Haul truck in Texas. At the time of his arrest, he was homeless and relied on collecting discarded items from trash cans to survive. He stored these possessions in the U-Haul truck, which functioned as his sleeping quarters. During the search, law enforcement officers discovered several items on Mr. Seekins, such as cell phones, a lighter, a flashlight, and a spyglass. Additionally, they found a single orange 12-gauge shotgun shell and questioned him about its origin, to which he responded that he had found it in a garbage bin. Initially, the police officers identified the shell found on Mr. Seekins as a flare gun shell and documented it as such. Upon searching the cluttered U-Haul, they discovered other items such as wrenches, jumper cables, and clothing for men and women. Ultimately, they came across a flare launcher inside the cab, which was later found to be modified to potentially shoot shotgun shells. Another shotgun shell was found inside the launcher. Mr. Seekins claimed that he discovered the flare launcher and the two shells in a dumpster, and he had no knowledge that the shells were shotgun shells or that the flare launcher had been altered to accept shotgun shells. Nevertheless, he was arrested and charged with being a felon in possession of a firearm due to his previous felony convictions. Initially, Mr. Seekins was charged with possession of a firearm under 18 U.S.C. Section 922 G1. In the original lawsuit, Mr. Seekins and his defense team notified the court of their intention to present an expert witness and testimony that would demonstrate the modified flare launcher did not meet the federal definition under the NFA and the GCA as a firearm. So, what did the government do? Well, they dropped the initial charge of being a felon in possession of a firearm and instead accused Mr. Seekins of being a felon in possession of ammunition because of those two shotgun shells they found. But there was no evidence in the case record suggesting that Mr. Seekins engaged in any commercial transaction involving the two shotgun shells or that he acquired them by purchasing or transporting them across state lines into Texas. The government failed to provide any evidence to support their claim that Mr. Seekins bought or intended to sell the shotgun shells. They did not attempt to show when, where, and how the shells could have crossed state lines to the point that Mr. Seekins violated the Commerce Clause. The government could only present a witness who showed that there was a very high likelihood that the company that made those shotgun shells was located in Illinois, but that witness couldn't prove without a doubt that those shells indeed came from outside of Texas. There was still a small possibility that the shells were made elsewhere and then transported to Texas, or that the shells were made in Texas. As a consequence, Mr. Seekins was sentenced to 70 months of imprisonment for violating 18 U.S.C. Section 922 G1, which reads, quote, G. It shall be unlawful for any person, 1 who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year, to ship or transport in interstate or foreign commerce, or possess in or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. End quote. So he was sentenced to 5 years and 10 months of incarceration, even though the two shotgun shells the police found came from a dumpster. Again, no one could prove that Mr. Seekins purchased it from outside of Texas. But we all know how broken our justice system is here in America. So, moving on. Mr. Seekins filed a petition where he argued that the application of 18 U.S.C. Section 922 G1 against him, based on these absurd facts, is unconstitutional, as it represents an unconstitutional extension of Congress's commerce powers. He initially sought a rehearing in the Fifth Circuit, but this was ultimately denied, because the Fifth Circuit voted 9-7, with only 7 judges in favor of rehearing, so they were outvoted. For that reason, Mr. Seekins has now filed a request for Supreme Court review, and that is why this case is currently before the Supreme Court. Mr. Seekins is petitioning the Supreme Court to review his case and determine whether 18 U.S.C. 922 G1, as it was applied to his specific circumstances, was unconstitutional. He argues that Congress can only regulate activities that have a substantial effect on interstate commerce or have an evident commercial nexus to interstate commerce, as recently held by the Supreme Court. In this case, it seems that Mr. Seekins is attempting to build on the precedent set by the 1995 United States v. Lopez case. In that case, Alfonso Lopez was arrested for carrying a concealed weapon into his high school and was charged under the Gun-Free School Zones Act of 1990, a federal law that prohibited individuals from possessing guns within school zones. In a 5-4 decision, the Supreme Court agreed with Mr. Lopez that the Gun-Free School Zone Act of 1990 exceeded Congress's power under the Commerce Clause, and thus struck down the federal law. The significance of the Lopez ruling was that it marked the first instance in which the Supreme Court had invalidated a law based on Congress's commerce powers since 1937. This decision was significant because it signaled a rare instance in which the court had challenged Congress's use of the Commerce Clause. Mr. Seekins is attempting to apply the same reasoning to challenge the use of the Commerce Clause against him, as in the Lopez case. He is contesting the clause's application in his case, where he merely had possession of 2 shotgun shells that might have crossed state lines at some point. This is a noteworthy challenge that could affect Second Amendment cases and our rights under it, without actually raising a pure Second Amendment issue. So, why is Mr. Seekins' case so important? Well, it's important because there have been other recent lawsuits with similar allegations, such as the Texas suppressor lawsuit and the bill that was passed in Texas regarding locally made suppressors. In that lawsuit, one of the claims made by the state of Texas is that the ATF lacks the authority to regulate suppressors made in Texas under the NFA because such suppressors do not affect interstate commerce. This argument is based on the claim that the ATF cannot claim the Commerce Clause powers of the NFA to regulate items that do not implicate interstate commerce. A case such as Seekins has the potential to greatly challenge the Commerce Clause powers claimed by the NFA and GCA, and could have far-reaching implications beyond just felons in possession of ammunition. It could also affect felons in possession of firearms and other items. This case could have big ripple effects on other similar ongoing cases, such as the Texas suppressor lawsuit. Although it may not be a pure Second Amendment case, this is an interesting and important case that could have significant implications for Second Amendment rights and the authority of executive agencies like the ATF to regulate firearms and ammunition. It raises questions about whether Congress truly has the power to regulate such items and how far their authority extends. The decision of whether the Supreme Court will hear this issue is pending, but the case is currently before them. Hopefully, the Supreme Court will remand this case to the lower court for dismissal. I'll let you know of any updates when I hear about them. And we've reached the end of this video. I'm of the opinion that anyone who hasn't had felony charges against them for the last 10 years or so should have all their rights restored, including their rights under the Second Amendment. But what do you think? Should 18 U.S.C. Section 922 G1 be revised? Comment down below. Please help the channel grow by clicking on the like, share, and subscribe buttons, and click on that notification bell too while you're at it. Thanks, and have a good one.